right, looks like everybody's unpacked and ready to go, so we'll proceed. Mr. Hill, reserving 5 minutes. Would you like anything different?
6 would be great, Judge, because that'll keep me from running too far into the 5, if you don't mind.
All right.
May it please the court, Christopher Hill on behalf of IR LLC, the appellant. As I say appellant, I ran into a recently retired judge from the 9th, and she asked where I was going all dressed up. I said I was coming here for oral argument. And she said, oh, are you the appellant or the appellee? And I said, appellant. She goes, ooh. So I hope it's not that much of an uphill battle. So we're here on appeal of a summary judgment granted in the court below. The facts of the case are very simple. My client is IR. They're an HVAC manufacturer. We hired the appellee, Coyote Logistics, as a logistics provider to forward some of our HVAC systems up to Indiana. Coyote, on the other hand, hired ISP, IS Progress, as the carrier. The carrier somehow, during chance, we allege, the carrier somehow caused this shipment to shift and become damaged during transit. Coyote has sued below IR saying, you owe me payment for the shipment, plus a bunch of other shipments. We have counterclaimed. We counterclaim saying, number one, breach of contract. We don't owe you for that shipment because it was ruined. And you owe us for the damage to the HVAC system that was in transit. Judge Falcone granted summary judgment on their claim against us. And counsel before said you should narrow the issues on appeal, and we have tried to do that very well. So there are a lot of things with Judge Falcone's order that we are not appealing up here today. We specifically I can't quibble with his decision on the contract. He found a contract, there was an agreement as to price, that's fine. I think we can agree that that was stipulated. So, but what we do have trouble with is Judge Falcone's ruling that our breach of contract claim was somehow precluded as a matter of law. So he found that there was a breach of implied contract, and he found the implied contract that had been established under the summary judgment standards so that no reasonable jury could find in our favor. So we appeal that ruling. The second ruling that we would contest is Judge Falcone's decision that the tort claims, our tort claim for negligent retention and negligent hiring, are somehow precluded under the Federal Aviation Administration Authorization Act, or as we call it, the F-Quad-A. So those are the two elements.
All right. On your breach of contract case, your counterclaim, you said there was a disputed issue of fact in terms of what the terms of the contract were with regard to your client had an understanding that Coyote had promised, I guess, that it would safely transport the goods, and Coyote saying, we never made that promise.
Yes, sir.
You're relying, it seems to me, on the affidavit of Joseph Johnson, which is in the record, which in large part reflects his understanding or the company's understanding. Is there something in his affidavit that says this is what they promised us? Actually, not, you're looking at their website, he's got some documents, all the rest of that, but it's not, they promised us, they told us this, and I know we're going to hear from the appellee that Johnson wasn't all that involved in choosing Coyote or dealing with Coyote, but put that to the side. We'll wait for that later.
And I think you're exactly right. I think that's where the court has to focus, and it's the record on pages 1141 and 1142 is the affidavit of Joseph Johnson. He does state that he was involved in the retention and selection of counsel, including logistic providers. I know they critique his basis for that, but they chose never to depose him, so his affidavit stands as far as the facts of the lower court. Mr. Johnson does go in, so again, reviewing this from the court, he does say that they provided us with the insurance information.
Well, this claim arose in March of 2018, and the insurance policy he talks about expired January of 2018. So,
yes, sir.
If he was going to rely on that, he ought to have gotten an updated policy, maybe.
Again, yes, sir, Judge. But this, again, we're talking about the implied contract. So, again, we have to go back to what did Judge Falcone found. He found a contract implied in fact. And for the contract implied in fact has to be established through the conduct of the parties. So the conduct of the parties would be everything leading up to the event that we're talking about, which would include the provision of the certificate of insurance. And it sounds like a small matter, and I understand, well, they gave you the insurance policy. But if you think about it in the context of this business, and in the context of any other business, like a construction industry, when I give you my policy and I give you my certificate of liability insurance and say, hey, I'm fully covered, I'm here, I'm a good, solid company, I'm fully covered. For what? Well, I'm fully covered for loss. It was a CGL liability policy that would cover our losses in the event that the cargo was damaged. So it's not a small matter. And if you read, Mr. Johnson goes on to say, it was not a small matter to IAIR because we logged what their policy was, and because they had a $500,000, a higher limit policy, Coyote was then eligible that we didn't have to break up shipments. In other words, if a carrier had $50,000 in coverage, we would never ever ship $94,000 of goods with them. We'd have to break it up into 2 shipments and pay 2 shippers because we want full coverage for each component.
But where does Johnson actually get in his affidavit? Because I'm not aware of any other facts you're pointing to other than what's in his affidavit. Where does he actually say that Coyote told us, represented to us, that they would safely transport the goods and stand behind it?
Again, Judge, if there's not an affirmative, overt representation. In fact, one of the problems you have in determining what was the meeting of the minds of this contract that was implied in fact. That's what you all have to figure out on review. It was the totality of everything that went on between them. There's not an overt statement, to your point, that says, hey, we'll cover you, or here's an email that will cover you. In fact, there's no contract at all. There's nothing. And we live in a world of disclaimers. We live in a world where every invoice has limitations of warranty on the back. There's nothing, and it's as a negative, it's not an affirmative representation, but in evaluating the conduct of the parties, there's nothing from Coyote coming to IAIR saying, hey, we won't be responsible for any loss. Your only loss is against the carrier under Carmack. Good luck. We'll give you a hand if you need to sue them, but we're out.
How does the bill of lading play into the conduct of the parties and the legal significance of the fact that the appellee did not execute the bill of lading?
Judge, and that's a good point. But there are 2 bills of lading. If you look at the record, it's in the appendix, pages 127 and 129. One is signed off on by ISP. One is actually signed off on. It has the notation on it that talks about the damaged equipment. So yes, under the traditional rules and under Carmack, the carrier, which is IS Progress, we're not contesting that IS Progress was the carrier here. The carrier would sign off on the bill of lading. Coyote is listed as the third party. So again, that's not, yes, is that the way it would work, and did we know there was a carrier involved? Of course. We understood that. They're a logistics company. We know that they're going to use a carrier, and the carrier, by rule, is going to sign off on the bill of lading. But that in and of itself does not contradict the understanding that Coyote would have had as to what is going to happen for this loss. And if you compare the two, there's one where it talks about the loss, and I don't know if ISP declined to sign off on that bill of lading or what happened, but that one is not signed.
You're not appealing that the Carmack Amendment bars your claim against them as a carrier.
That's fair, and that's one of their overriding arguments. You're right, Judge. So they've made both overriding arguments saying, no, they alleged we were a carrier, therefore a carrier can't be sued except under Carmack, therefore they're totally out of luck. That's not what we alleged. Again, if you look at the record on page 62, we alleged that they entered into agreement to transport freight. Okay, that's true. We knew that they were a broker, but our position is, and has always been, that as the broker agreement, they had additional duties. They had additional duties under contract, and they had tort duties under Florida law. If you look at the definition of a broker under the Carmack Amendment, it's 49 U.S.C. 14706A1. It says selling, providing, or arranging for transportation by a motor carrier. That's exactly that's in no way inconsistent with paragraph 16 on the record of page 62 of what we alleged against them. So that they've argued that as an overriding argument. We're not alleging they're a carrier. To the extent we did, I think the judge was right that those claims are precluded and you can proceed solely under Carmack.
Right.
On the contract issue, though, how does the jury make that leap if we're looking at summary judgment through the lens of whether there's evidence that a regional jury could accept? How does the jury make that leap from there's insurance for loss to you assumed a specific set of legal liability.
And Judge, I get what you're saying, and it does come back to, as Judge Edwards said, it comes back to, wait a minute, they gave you this insurance policy. And I think to the jury, we would say, well, yes, but there's more than that. There's more than, if you look at the way these logistics companies, it used to be that, pre-internet, no one had the ability to find a trucker who wanted to go from Orlando up to, I think they're going somewhere in Indiana. That was not a possibility. Well, we have the internet now. You can go to UShip and find somebody in 20 days. So companies such as Coyote are selling themselves as more than just a broker, more than just putting you A and B in touch with each other. We are a logistics support. If you look at, no, this was in part of the record, it's the appendix, page 34. They call themselves Collaborative Transportation Management. Tap into your entire supply chain via a web-based platform designed for your every consultative, executional, and transactional supply chain need. Well, what we needed was coverage, and what you gave us was proof that you had coverage in case there was a loss with one of the carriers you
So
picked.
these kind of like general assurances and some of like an advertisement context.
Yes, sir. Yes, Judge. And I think
That's what the jury would have to rely on.
Yes, Judge. But I think, again, the jury's going to have to, and what the judge did, and the judge rejected Mr. Johnson's affidavit in a footnote of the order. But to your point, what the jury has to say is, all right, I have a contract implied in fact. Well, implied in fact kind of refutes summary judgment on its face, but we have to go further. What is how are we going to figure this out? Well, you have to look at the course of conduct of the parties. Well, if I'm Coyote, I'm going to say, well, they called us a broker. True. It's a term of art that everyone throws around. We knew there was a carrier. True. We knew that there would be someone else. But everything else lends it to, there's nothing inconsistent with IAIR's understanding that there is more to this relationship than just putting A to B and hitching us a ride to Indiana. Why would you give us this insurance? Why would you show us that you're fully insured if, number one, you're immune from tort, and number two, I can never sue you in contract, and there's no contractual relationship? The other point that I would make to the jury is, if you look at the ISP agreement, that's in the record, pages 487 to 495, the Coyote ISP agreement specifically addresses potential liability to us. So again, there's no agreement, this implied in fact agreement, no document between IAIR and Coyote. But if you look at between Coyote and ISP, the carrier, there's a very strong agreement. And what they have in there is everything that you would expect to see from a company that knew it would be on the hook if something happened to the product. They have a very strong indemnity provision to ISP. They require ISP to carry insurance itself, and then they also require ISP to make Coyote an additional insured under their policy. Again, if we analyze the construction industry, it's exactly what you would expect. If the general contractor is going to be responsible, I make sure that my sub has coverage and has a bond, and I make sure they indemnify me. And, oh, by the way, I want to be an additional insured under your policy. So they have to look at the totality of everything that went on between the parties, the agreement and the understanding. And yes, Judge, the provision of the certificate of liability insurance is a huge part.
I'd say I don't mean to interrupt you, but I do, because I'd like you to turn to the F4A.
F quad A, our favorite argument.
FAA.
This is, and I'll concede this is Mr. Hansch's specialty. So,
I mean, to me, looking at the cases, it depends on where you are, because they all talk about exactly the same thing, and then half of them come down one side, or maybe not half. I'm sure we'll hear the majority come down on one side and the minority on another. But, I mean, even down to Judge Presnell in Orlando, he talks about it doesn't preempt a negligent hiring selection claim if it's a personal injury, but does for property. And then talks about embryos, fertilized embryos, as whether they're people or property. I mean, it's like,
Judge,
why should we come down on your side rather than the other side?
And I think your point is valid, and I will concede to the court. If you total up all the cases, more than 51% probably go their way. And I've tried to reconcile the cases, and you all are smarter than I am, maybe you can do it, but I don't think there's a way to do them. There's just two lines of cases and two schools of thought. But the idea that I'm somehow this minority thought is, no, it's a very large school of thought that there is no preemption for this type of tort, negligent retention.
Right, it's not just one outlier, but
No.
you know, the minority view is it doesn't. And, you know, everybody uses the same language. They look at, oh, is this a core? Is this related to? Is this tenuous, direct, indirect? Why should we come down on your side
Two reasons, Judge. And I think that the Covenant imaging case is the one that I relied upon below and the one I would rely upon in our brief. I think that sets out my argument as well or better than I can. And what they go through is the preemption analysis. And I think you all saw this. There's two levels. First of all, you have to find that it's potential, that the tort of negligent hiring is potentially covered by the preemption provision. And then you have to decide, number two, does this safety provision allow the state of Florida to come in and say, yeah, even though it's preempted, for safety purposes, we're going to decline to find preemption. The reason, honestly, is, Judge, it's just as the Covenant said. We have to start off with the concept of preemption under the Supreme Court in Roe and versus Morales. You should be very cautious about not finding preemption when there's something specifically designed. You know, in other words, if Florida had enacted a statute designed to impact trucking and the services and the rates and the routes of trucking, your alarm bells should go off. But when we have a broad-based, common law statute that applies to everyone, everyone has a duty to be reasonable, to act reasonably in hiring and retaining people. What the courts say and what Covenant and all the other courts that go this way say is, wait a minute, they're not trying to impact trucking. They're just trying to say that is a duty that you cannot shirk just because you're a broker and just because the F Quad A exists. The people of Florida are entitled to have you comply with that duty. As a corollary to that, under the Miller, they cite Miller, but Miller goes our way. Miller says, well, it could be preemption, but because tort law is the bedrock of safety, which is what the Ninth Circuit says in Miller. And because if we allow brokers to not have any responsibility for who they select or how they select them or vetting them or making sure they're insured, then you've completely eviscerated that type of protection.
You're well into your rebuttal time. You can keep going,
Judge.
you can say that.
I appreciate the warnings.
All right.
Good morning.
I'm sure we're
guys.
going to hear the exact 180-degree flip here, right?
Perhaps.
All right.
Our viewpoint of this case, Your Honor, is that this court should analyze it through both the pleadings and on the record. And in either instance, Coyote is entitled to an affirmation of the court's entry of summary judgment. Critically, to provide context, the services are federally regulated here. Both providing transportation as a motor carrier is a specific regulated service that requires a license, as does arranging for transportation by motor carriers. That's a separate broker's license. And I draw to the court's attention that the threshold issue in this matter is that, contrary to a contention by opposing counsel that there was an allegation that we were a broker, within its counterclaim, no such allegation exists. Instead, there's only allegations that Coyote agreed to transport the shipment. And by using that phrase, it's triggering and coloring Coyote's status as a motor carrier, which would then trigger Carmack preemption, because both claims sought to recover for damage to property against the motor carrier. Quite frankly, Your Honor, the case need not go any further than simply that pleadings analysis finding. Ayer, you pled that Coyote had agreed to transport the shipment. Those are motor carrier services, and therefore Carmack applies.
What's your response to this kind of exists outside of that issue because they've, separately argued the implied contract, and the jury can make this leap if they rely on the provision of insurance and the general assurances?
Going beyond the Carmack preemption on the pleadings on its face, if somehow this analysis continues to Coyote is a broker and we're looking at an implied term. One of the hallmarks of an implied term is that it is unwritten, and therefore you must look to the parties' performance between them. And here, for instances of trying to find any course of performance to show that Coyote undertook the representations and obligations alleged by Ayer, they cite to no instance of any shipment where Coyote, in fact, undertook to perform in the way that they have alleged. So there were 45 shipments, for example. None of them did Coyote ever agree to respond to and cover a cargo claim. And so the attempt to introduce the affidavit.
I would assume there hadn't been a whole lot of damaged shipments before this one, or they would have found somebody different, wouldn't they?
Well, Your Honor, Coyote does engage with thousands of different motor carriers, so their relationship with IAIR may have involved several different
Right, but
motor
y'all,
carriers.
I mean, the argument that appellant's making is, y'all didn't just say we're a transportation broker. You said we're logistics, and, you know, on the website, it looks like y'all do a lot. I agree, it doesn't say that y'all transport things. But, you know, it's not like we're just a transportation broker, we're a matchmaker. We do all kind of things. And aren't they entitled to rely on that representation of being in logistics, and you give them a huge policy of insurance to take a look at? I mean, under your view of the relationship, you owed them no duty other than to have somebody show up, period. Right?
Your Honor, that is the contention, and I think this Joe Johnson affidavit does not exist on this record on its own. Instead, what we see, that affidavit was introduced only after Coyote pointed the trial court, and the trial court properly recognized that the very first thing that Coyote sent to IAIR.
You have a signed copy of the credit application?
Your Honor, in these facts, there is no signed copy. However, it's undisputed that it was sent, disclosing that Coyote is a broker. We are not a motor carrier. So in response to your question, it was very clear expressly from the beginning that we were disclosing a broker role, followed by, I believe her name is pronounced Seni Ortiz, the representative for IAIR, who, for all intents and purposes, was responsible for the IAIR customer, the purchaser of the HVAC units. That was the customer representative. She was involved in dealing with Coyote prior to this transaction, arranging the transaction, and even after the acts or the alleged damage occurred, she was the one who stated multiple times, this is Coyote's the broker I hired. I'll file a claim with the truck broker. So there are repeated admissions on this record, which are binding to IAIR as an organization in totality, that Seni Ortiz's knowledge of Coyote as a broker was imputed entirely. This Joe Johnson affidavit is just an unsuccessful attempt to quite literally state a person, meaning Joe Johnson's belief as to Coyote without any explanation when the website was visited, whether he had any transaction specifically for this shipment. So it's totally doesn't give rise to a genuine dispute for a jury to find in favor of IAIR.
Do you want to discuss the FAAA preemption issue?
Your Honor, I believe in listening to counsel for appellant, the F-Quad-A simply is a statute where any state law that's enacted that relates to the price, route, or service, not just of motor carriers, as IAIR contended in its briefing, but it applies to motor carriers and brokers.
Right.
The universe is such that the test is related to is broad, and there's also a prong under the F-Quad-A that doesn't exist under its corollary in the airline industry, which it must concern the transportation of property. So for purposes of this case, IAIR has conceded that. We're just looking at, does a negligent selection claim arising under Florida state law relate to the service of Coyote as a broker? And quite frankly, Your Honor, it's a bullseye. IAIR admits as such, stating our claim goes directly and is directed to the services that Coyote is performing. So this isn't tenuous, this isn't remote, this isn't some incidental effect, but rather you should have assumed certain obligations under state law at the time you were performing your service.
Well, to say it's a bullseye, I think maybe a little bit strong. A bullseye would be if the state was trying to regulate, directly regulate the rates and the services and all the rest of that. Related to, I'll give you that argument, but in terms of a bullseye.
I believe, Your Honor, the bullseye I'm contending is that its effect is a bullseye of being precisely that type of obligation at the time. I believe the minority of cases gets their position wrong because they look at whether or not the statute must be targeted towards, motor carriers or brokers. That's not the analysis. The analysis is instead, what is the law's effect? And I also want to provide the court, we understand that there are cases that may go one way or another way. For purposes of F quad A analysis, we must look at the fact that this case did not involve a motor carrier accident. So many of the cases which speak to the safety exception cited to by counsel for air are completely in opposite because we're not dealing with the safety exception. There's no implication of any safety regulatory interests of the state of Florida in this action. So when reviewing the cases, to keep that in mind, you'll then see that there's almost a much stronger majority of F quad A preemption when you're dealing just with the cargo claim.
The covenant was just a cargo claim, wasn't it?
Your Honor, that's correct, and frankly, I believe the Judge Brian Davis's more recent decision out of the Middle District of Florida is more appropriate and faithful tracking of F quad A jurisprudence. I'll point out that the only Circuit Court of Appeals which has dealt with this matter in the Ninth Circuit had no trouble finding that a negligent selection claim there against a broker related to its services.
But then they found the safety exception applied, correct?
Correct, because it was, as I'm pointing out, a motor vehicle accident involving personal injuries. This case is distinct. It's simply a cargo damage claim.
That's kind of looking at it after the fact, whether it's preempted or not. In other words, if it's the correlation to the service provided, the safety factor, oh, it's okay they didn't get in a wreck this time, whether it's preempted or not. They didn't get in a wreck this time, the wood fell out, or in the covenant case, the magnet got frozen for some reason. I mean, it seems like a little odd way to run a state of laws that applies to whether there's preemption or not.
Instead, the analysis is, or to your point, the analysis is simply that the first step is to find the relating to and the fact that it's targeting those obligations at the time they're performed. Then a safety exception, which by its terms simply does not exist here. So to your concern, should another case implicate facts or implicate issues which more appropriately fall within the safety exception, that's simply a decision for another day. Today, the safety exception has not been implicated. There's been no allegation of a breach of any law or regulation under Florida law, which protects the motoring public, and so therefore the decision could be limited in that way. We wouldn't need to address a different context.
Go ahead.
Simply F quad A in the cargo damage context.
Some of the cases look at whether the shipper would have any other remedy, and they say, oh, it's terrible here, there's no other remedy. And your answer to that is, well, they can and they have sued IPS.
That's correct, or an IS Progress. And so they're not precluded from any recovery from the party who, no allegations as to Coyote's involvement with this piece of wood, but there's a disputed piece of wood which was taken out of these from underneath the HVAC units. And so they still have a recovery available from a party, and in fact it remains pending in the trial court. And simply for Coyote's purposes, we were alleged to be a carrier, being alleged to be a carrier who agreed to transport, and there's a cargo claim, Carmack preemption is triggered. When it comes to the implied agreement, we've seen no course of performance, and Joe Johnson's affidavit fails to overcome the admissions of Senny Ortiz and the representation. Finally, for F quad A, we have a case where a negligent selection claim against a broker clearly relates to the services. The greater weight of the authority supports that contention, as well as the Ninth Circuit, and there's no safety exception, followed by you still have your Carmack claim. And for those bases, Your Honor, we would ask that the summary judgment order be affirmed.
All right, thank you.
Your Honors, I'll try to go in reverse order since I short shrifted the F Quad A. Starting in last with the safety argument. Judge, I think you hit it on the head, and Judge Davis did this, and even Judge Presnell did that. It was a results-oriented decision. In other words, the question shouldn't be, well, was anybody hurt on this claim? The question be, by not preempting negligent retention and negligent hiring, are we making the citizens of the state of Florida safer? That's the question. Are we going to allow?
I mean, is that not skipping step? Do you agree with the general rule that preemption analysis is whether it relates to, I skip the rest, the service in this case?
It's the actual standard is whether it has a significant impact upon a rate, service, or route of a carrier. Yes.
And so what's your response to the argument that selection, hiring, if you will, is a core function of a broker, and so that directly relates to the service?
Again, the diversion of case law, the cases on the covenant side that side with what we're arguing say there might be some impact. We can't say it's zero, but we can say that it's not significant. We can say, well, yes, if there's liability, do they have to alter their things to some extent? Possibly, but it's not a significant change in what they do. And the Nicewater case, which is cited within covenant, says, well, wait a minute. The service that Coyote is really the interaction between Coyote. That's what we have to focus on, the interaction between iAir and Coyote. And as long as iAir isn't trying to go and get a better rate or something because of the law, or in this case, the common law, then it really doesn't affect their service. It's more of I guess, the backroom type operation of somebody like Coyote. And I guess, we can talk it in the abstract, but in the specific, this case, is there any impact at all? So what would they have to do if they were going to be exposed to tort liability? Well, they'd insure themselves. They did. They would try to make sure they're indemnified by the carrier. They are. They would try to make sure that the carrier had insurance. They did. And they try to make sure that they weren't additional insured under the carrier's policy. All of that has already been done. The impact is none in this case. And I think that's what the covenant line of cases say, is that everybody in the world knows, everyone protects themselves. Just allowing there to be some remedy in the case they don't really do what their core job is, which is to select a competent carrier, that clearly promotes safety. Whether or not the cargo falls off and kills somebody or not, it promotes safety to the people of Florida, and it clearly is going to have a negligible, if any, impact on the overall operations of the core services. So again, yes, there are cases that say that. I have to concede that, but there are also cases saying, wait a minute, that's not going to affect how they do business. And then that goes to the second element. So we have the safety that kind of bleeds into what type of impact would it have. They're two separate, under the statute, they're two separate provisions, but they are somewhat related. I would submit to the court, the evidence in this case is there's none. And you're right, Judge, we shouldn't make a rule based on whether or not the cargo falls off and hurts someone. The rule should be, are the people safer because we allow this type of cause of action? Because a carrier in Florida knows, or I'm sorry, a broker, logistics provider in Florida knows that if they don't do their job, they might be responsible to us and others. So that's really where it comes down to as far as the F Quad A. Again, to Judge Falcone's credit, there are cases that go the other way, but I think the more reasoned cases seem to take a very closer analysis. Even the Gauthier case that's cited by Appellee says it's a fact-specific case. We have to look at the claim, and we have to look at the particular impact in this situation. In this situation, there's zero impact, much less a significant impact.
And you need to look at the red light. We're done. Thank you very much. Very interesting case. Well argued, well briefed. We're going to take a